So it's 8 o'clock. As the Vice President of the Whatcom County PUD, and with our President in absentia, and hopefully not worrying about PUD at all, Commissioner Christine Grant is, as the President, is temporarily excused while she is attending to the delivery of her next child. So in that capacity, I'm taking over as the Commission President for this meeting, the next meeting, and on a standby basis until she returns back to service at the PUD, Commissioner Grant, that is. So with that, I will call this Whatcom County PUD Commission meeting of Tuesday, July 26th to order. And let's start with the Pledge of Allegiance, and I'll go ahead and recite it. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. So the next item is, of course, the approval of the agenda. At this time, does anyone have any changes or amendments to the agenda?
I personally do not have any changes, Altuo.
Great, then let's make a motion to approve the agenda.
I'll make a motion that we approve the agenda as it reads.
And I will second that. So we have a motion and a second. All those in favor, please signify by saying aye.
Aye.
Aye. So that deals with the agenda. Let's move on to the next item on our agenda, which is the consent agenda. And under that, we have the meeting minutes of the regular meeting and the claims for of our last, regular meeting of July 12th, and the claims for July 26th.
Commissioner, I have one addition, if I may, under Commissioner reports for Commissioner Grant. On the last bullet item where it's noted she will not be at the next few meetings and she welcomes a new member of the family, what I had discussed with Commissioner Grant and mentioned in the meeting was that absence was excused by unanimous consent. I'll make a note, if you accept that change, I'll pass it on to Tracy.
Yeah, I'm not sure where to just put that on in the minutes. Is that something we want to make sure gets reflected in the minutes, John?
In my conversations with Commissioner Grant, that was a preference. There's a time limit for missing meetings that are unexcused in the statute.
Would you mind,
so,
John, if then we just put that under the minutes under General Manager's report? Chris and John, is that okay?
It just seemed to fit under the Grant Commissioner report where absence excused by unanimous consent.
And that's
Okay,
where the
yeah.
discussion
That's where
actually
the
was.
discussion occurred.
Sure, okay. So we're.
I'm just going to add that sentence if you will. I would propose adding that sentence.
Great,
Absence
that's great.
excused by unanimous consent.
Okay, that's fine. So with that change, I guess we just made a motion and passed it for approving the agenda. Are you okay with that change, Commissioner Murphy?
I am, and if you wish, I can make a motion that we approve the consent agenda with the changes recommended by John Sitkin.
Great. I'll second that. And so let's vote for the motion again. All those in favor, please signify by saying aye.
Aye.
Aye. So I don't know if we want to reflect in the minutes that we had two motions to approve the agenda, or just refer to the second motion.
I refer to the second motion.
Yeah, we'll just say that that there was some revisions that were moved and accepted, and that was what was voted in.
Okay. Let's move on now to the consent agenda. Again, we have the meeting minutes of the regular meeting of July 12th and the claims of July 26th.
I'll make the motion. Go ahead.
Go ahead.
You want me to make the motion? I'll make the motion then.
Thank you.
Okay.
And so there's a motion to approve the meeting minutes of regular meeting and the claims of July 26th. All those in favor, please signify by saying aye.
Aye.
Aye. And now let's move on to public comment. Who's can help me with checking to see who are the commenters and letting them in?
So, Mr. Commissioner, we do have one member of the public that's present in the conference room. Mr. Miracle, would you like to say anything?
Just best wishes to Commissioner Grant.
This
Mr.
is-
Miracle says extends best wishes to Commissioner Grant. And then I'll
Thank
ask
you, Rick.
Rebecca. I'll ask
Yes.
Rebecca to take a look at Zoom. Sorry, Rebecca, I keep stepping on you.
That's okay. I have no one raising their hand at this time.
And Commissioner Deshmani, you could also, if you click the participants view, you can also see who the attendees are as well.
Yeah, I'm looking. I'm just,
Okay.
I'm not seeing anybody else
Yep.
raising their hand to speak. So as a result, I will close the public comment period. All right, thank you. Let's move on to the next item in the agenda, and that is old business. And the first item under old business is to approve the final strategic plan update. John, are you handling that or is?
No, I am.
No.
Okay, sorry.
So it's okay, Commissioner Deshmani. If you'll recall, in our last meeting, we went over the substantial or substantive text changes and got some more input from the commissioners. Those changes were actually made and we engaged a graphic designer to work on it. We've had now 2 revisions of the graphic design. I don't have a final for you this morning. I should by our next meeting have the final for you to look at and approve. And as soon as I have the final version, I'll distribute it to all 3 commissioners so that you'll have some time to look at it. But I expect to have that this week, if not today.
Do you need any action from the commission today?
I do not, other than just note that I did not submit the approval, the final approval for you guys today, and I plan to bring it next meeting.
Yeah, that's fine with me. Is there any issues there, Mike? We'll just see it on the next agenda.
No, I'm good with cabling it till our next meeting.
And commissioners, I want to assure you, we know the content has been approved, so everything that's in there is currently being worked on, and we're moving it forward, including the items in the budget and everything else that's in it.
Great. So that concludes item 5A then. Looks like, gentlemen, and ladies, this meeting is going to be a little bit shorter than we even anticipated, and we may be looking at setting a record for the shortest PUD meeting of 2022. I don't want to jinx it yet, though.
Rick remembers the 30-second meeting.
Well,
Yeah.
that was the old days, though. I'm talking about under the new days. The next item on the agenda, 5B, is a broadband program update.
So let me give the update in on a couple of different topics. One is we're making a lot of progress with NOAANET and Petrichor on a feasibility study for setting up a publicly owned ISP. And we should be able to bring that back sometime late in September. I just want to let you commissioners know that there's significant amount of time being put on this by both Andrew and myself, and then of course our consultants. The consultants are paid through a grant from the state and some minor matching funds. So it's a good study, and I think we'll be really happy to present it to you guys. So that's the first thing. Second thing is that we've had a lot of discussion with public groups. And in fact, we talked to the TAG Northwest group last Friday about serving several different areas using different models. We talked about just helping the public do this on their own. We talked about an LUD type model. We talked about a fiber hoods type model along what Lake Mason is doing. So we're looking at all of these different things. We've had a presentation on the LUD model from Kitsap County, PUD. And there was so much interest and the appearance that maybe this was something that we could do, that we made a significant investment on how to do that and what could be done. Part of that was to take a look at the process that we had to go through in order to do an LUD. And that, of course, raised a whole bunch of questions of, well, gosh, do we have authority to do this? What's the legal and right way to do that? What are the limits? What are the rules around this? And we asked John Sitkin to take a look at that. And what I'd like to do now is turn it over to John. He's got a bit of a review. And again, the topic here is really kind of what are the rules and boundaries for LUD activity that we might in the future contemplate. So John?
Chair and Commissioners, this follows our prior
John,
discussion.
before you began that, one of the things that that we can address is there are certain things that will be discussed as it relates to the LUD model and risks to the PUD that may be appropriate to happen in executive session. And there's aspects that are very important to discuss in the public. And before you get into your summary, it'd be good to educate the public a little bit about how we go about making a decision about what deliberation to have in public. Of course, our decisions are made in public. They must be made in public. But the considerations and the analysis that commissioners may need to do in executive session and as they relate to contract related negotiations. So if you can just give just a quick synopsis of how we decide what goes into the executive session on that subject, and then what we're going to discuss today in the public.
Certainly. Today's discussion, I'll do both, Commissioner. That was my intent. Today's discussion is going to be focused on the process of formation of an LUD and what it's used, how it's used, what the full process is. It's not a simple one-time action by the PUD Commission, and there's financing available for development of infrastructure. So I'm going to go overview the process, and that's a public discussion. The executive sessions under potential litigation, it's defined as, threatened and potential litigation, as well as discussion of legal and financial risks associated with potential action. And those things could lead to litigation. And so we have some of those discussions of financial and legal risks associated with potential action in executive session. And the commission asked me to provide a high-level overview of the LUD process and some of the curb lines in statutes as to the authority. So I'm going to try to avoid delving into analysis discussion in public of those risks and financial risks that I've shared with the commission and recently sent you a memo, attorney-client privilege memo that you'll have in your system. But I'll do a high-level public discussion of the process and touch on some of the issues that are in the statutes. So an LUD is a financing tool.
Thank you, John. Thank you for that. That was very helpful.
An
Keep
LUD,
going. Sorry, thank you.
an LUD, a local utility district. People often are familiar with this because cities and counties use those for construction of infrastructure, financing of infrastructure to the home or to industrial development, commercial areas. You see it with roads, sewer, water facilities most often. And the city or community or entity has a project in mind. They form a preliminary assessment role. The commission, the elected body, adopts a preliminary assessment role, and that's based upon a scope of a project you've already defined by your engineers. And here would be a broadband or telecom project. It goes to the commission to form the assessment role, and that assessment role sets the boundary of the district, of the financing district, those properties that are in it that will be assessed, and that's going to be an important topic. If you're in the boundary of a local improvement district, you will be subject to assessments for the improvements that add a benefit to your property value. So you form the assessment role. If that survives challenge, meaning no one challenges it successfully, those properties within the boundaries will be assessed, and you go forward then and finance your project. A large project might have bond anticipation financing. You might do a note from a bank that does some interim financing to finance the construction with the plan that you will, when you have the final costs of construction and all associated administrative and other costs, you take that package and you take it to the bond market to sell for debt financing. And then the assessments against the properties are used to pay back the bonds over a period of time. So the property owner, when the project is done, has the benefit of saying, well, I didn't have to pay for the road improvements in front of my home. In this case, the telecom improvements to my home in a one payment. I got to spread those payments, likely at a low interest rate, over 10 or 20 year period. And so it's a financing tool to make improvements that the entity, the district would own, that the property owner has the benefit of. So you go through the process, build the improvements after the preliminary assessment role, which is the formation of the district. Then you go forward and adopt the final assessment role. And that is when you have the final assessments and you provide notice to all the property owners in the district that here's your assessment that we're going to charge your property. And it'll be paid out over this time. This is the estimated, this is the annual payment. And then you hold a public hearing. And you hold a public hearing and take any objections or comments to the assessments. And then you would pass the final assessment role, establishing and determining the assessments. The assessments are to reflect the special benefit to the property, meaning the value of the improvements, not the cost, but the cost of the assessment is not to exceed the improvement of the fair market value to the property by virtue of the improvement. So if your property value is X before you have the fiber to the home, it's X plus 2. Your special assessment or your assessment can't exceed the 2. If it does exceed the 2, it's potentially subject to challenge. And the property owner would have the burden of establishing that the assessment was in error, and they'd bring in some folks, some experts to testify to that. And that's all going to be laid out in a process and a notice that goes forward when you hold the final assessment role. You adopt that final assessment role and you send it off to the county, and it's assessed on your property. They get a bill every year. It could be part of the tax bill. It could be set at a separate billing outside of the regular taxing from the county. But that's kind of an overview of the process. So it's not a simple action of saying, we want to do an LUD. We're going to go down to institution XYZ. They're going to give us money and we're going to assess you a predetermined amount of money. And that's how we're going to go forward and finance the infrastructure bill. It's more complicated and there's more of a process. For telecom and in Washington, it's kind of a complicated statutory scheme, but there have been bond councils that have opined that the PUD do have the authority to use the LUD for telecom purposes, for telecom improvements. The statute that authorizes LUDs does not mention telecom. So that was a question we had. There are some other statutes that can be interpreted and have been interpreted by bond counsel to authorize the use of the LUD process for telecom. The Kitsap PUD doesn't use bond financing. And they've gone to financial institutions like a bank to lend the money. So bond is placing bond debt financing through the bond market is more complicated, more expensive. And I would assume for these kind of projects and the scale and scope are not really conducive to the bond market. And but I understood from Kitsap PUD is they didn't expect the bond markets to be interested in this product. And so they went to a local institution and obtained the financing because they had the ability to get an assessment. So you have to find a willing financial institution or a private financing to back and commit to these financing the debt, if you will, for the build. And that will be a separate process and a separate set of agreements that would have to be negotiated between the PUD and whatever financial institutions being used. one of the things that came out, it appeared from one of the presentations that Kitsap, and we've since clarified it. The thinking was that, well, you can be in the LUD, but decline to participate and not have to pay. And that's not the case. If you're in the LUD boundary, you will be assessed, even if you don't want the service. So parties saying, and when parties are out there getting a petition to form an LUD, they need to be contiguous and they need to be, and we can do it at checkerboard. I mean, contiguous we could draw a boundary down a road and capture a property, leave somebody out. It could be checkerboard like that. But you cannot assess a property. You cannot include a property in the boundary and then not assess them, because they will have, by definition, there's a theory they will have a benefit from the potential to connect. And so they will have an assessment. And those assessments must be proportional as throughout the LUD. So if a property owner really doesn't want to be assessed, they will be excluded from the boundary and excluded from the district, the LUD, the local improvement district, local utility district. Then you, with that property, should they 5-6 years later go, gosh, I wish I had that higher speed that my neighbors have, they come in and they pay one lump sum connection fee. They do not have the benefit of spreading their costs over the 10 or 20 year financing model at low interest. They may have to go to a bank on their own, maybe get a home equity loan to pay with the financing of the connection, but they're going to have to make a one-time lump sum payment. And that's the business decision that property owner will make when they decide to participate within the LUD or not. And so that's kind of the summary of some of the things. The other thing I wanted to mention is that if a property owner does join later and pays the one-time connection fee, how are those funds used? And there's a thought, well, maybe they can be used to buy down the assessments of the parties inside the LUD originally, and that's not the case. In theory, it might be possible. I can't see it working from a financial justification. And why I say that is, to change an assessment that's been established on a property, you have to go through the full final assessment roll process again. You say, these were the costs. Now we have more money to contribute. We're going to reduce the assessments. We have to redo the final assessment roll and change it. And that administrative cost, time, probably doesn't warrant, because all those new costs for that reassessment are going to be put into that second round of final assessment. And because you have $8, $10, $40,000 of connection fees collected to try to reduce someone's assessment over 20 years, but you're going to put $10,000, $20,000 of costs, administrative costs back into it, you're probably only saving a few dollars a month for that process. It just wouldn't make real economic sense in all likelihood. Both those funds, what they are used as a capital reserve account that could be used to fund future telecom projects, or capital reserve for maintenance and support of ongoing operations in that respect. So
John, one thing I want to point out, if you're charging someone $80,000 and they're a latecomer to one of these things, the reason you're charging them that is because that's what it costs to connect them.
that's right.
So there's probably not much residue left from that activity.
Right.
It may be a few $1,000s if your estimate's way off, but it's not going to be,
Right.
this isn't going to be a major source of funding or anything.
Right. There is that theory that's part of that connection charge, maybe buying into existing capital if there was an improvement that served a wider area plus the cost of connection. So you could allocate part of that connection fee to a capital reserve account that was buying into existing infrastructure, like if you built a middle mile and they bought into it. But you're absolutely right. There's usually the residual amount is not significant. The other thing that had come up, it's not really on the LUD, but it's on one of the approaches, is that can the PUD enter into these indefensible right agreements, IRU, people are referring to them. And we discussed this in time in other contexts with the commission in public, but a PUD has much more significant limitations on the sale of assets than a lot of other municipal governments. The PUD cannot just surplus property because I've determined it's no longer, that we have to make a sale of assets has to go to a vote of the people, which costs about 140, 150,000 for each vote. That's what we know from our commission elections. So to avoid that, you have to find that the fiber, in this case, be unserviceable, worn out, unfit, and no longer necessary or useful to the district operations. And that would have to occur at the time of sale or conveyance. So these IRU agreements that are 20 years, you can't decide in 2022 whether the fiber, the facilities in 2042 are obsolete or no longer useful to the district. You can't bind another commission on that. You can't make that decision of what circumstances 20 years in advance. So these IRU agreements where an ISP may upfront fund the install of fiber and the PUD gets some of the public entity gets some of the strands of fiber in exchange, and then in 20 years the ISP is sold, transferred back all of the fiber. That's not going to be possible in the structure of a PUD agreement. What could happen though is an ISP might get a right of first refusal. You could say, well, if we decide to sell it, if we find that it's obsolete, we will grant you a right of first refusal that, you know, if we decide to surplus it and sell it, we'll determine the price at the time, but you ISP might have a right of first refusal for that in 2042. That is the possible solution. So we wanted to give this kind of high level overview so that public was aware of the process, and it's not just a simple, let's pass them, here we have an LUD and we can go extend fiber.
Let's open it up for questions from the commission, if that's okay, John.
Sure.
So Mike,
Well-
do you have questions?
I do, Altul, thank you. John and Chris, maybe both you can jump in. I can understand an LUD for road improvements that I would use, sewer, water that I would use. But when it comes to such things as me paying for fiber hanging on a pole, and you did use the number 80,000. I don't know if that's a realistic number, Chris, per resident. I don't know if that's.
So I know of at least one case where that might be the case. The problem with it, there's no blanket number I can give you because it's going to be case by case specific. So some neighborhoods it's probably going to be $4,000 or $5,000. Other neighborhoods it's going to average 20, 25, and a few neighborhoods it's going to be very large.
Okay.
So it really depends on where they are and how much middle mile you've got to run to them and everything else.
And the concern that I have is, I think if I picked it up right, John, you'll have to correct me, but property owners pay for this fiber hanging on the poles through an LUD, through their taxes. And then 20 years go by and somebody can sell the rights to that fiber to another couple.
So no, you're mixing, there's two different processes. One is, there are two different financing vehicles. The IRU is distinct from the LUD. It's a separate process. So that notion of selling the fiber at the end of a 20-year period, that's only if you use the IRU agreement model with an ISP.
Okay.
And
Mark that
we're
on
not
the
discussing that. That's not connected to the LUD. John talked about two separate subjects.
Yeah, that's a separate financing model.
Okay.
That's why I say, you know, I went to that last one. It was a separate process. The LUD, the district would continue to own the fiber. Just like a city owns the road or the sewer or the water line, but it allows the private party to connect.
Okay. And I'm thank you for explaining that, because to think that the public would have to pay, the property owner would have to pay, and then down the road, someone sells this fiber for millions of dollars. Really, the property owners paid for it, but I'm happy that's not
It's
true.
a two distinct
Yeah,
process.
so I appreciate you clarifying that for me. The other part is I have private running down my road right now, and I have a choice to hook up to it or not. I pay for it to hook up to it, and I pay monthly on that if I choose to. However, if we go to LUD, it almost seems like to me that the property owner's already paid for it, and there shouldn't be a monthly service after it's connected to the house.
Well, that's the question of special benefit. You know, if you have an unserved home and then now you have fiber, there's a benefit to that property owner that some appraisers or real estate agents could calculate the differential in the market of served versus unserved home. You already have some fiber, even if it's not fast, you have a benefit already. So the only new benefit might be what's the increase of speed. That'll be difficult to calculate. What is the value of the improvement to the property value? Your property, because you went from speed X to speed double Z. And that's an issue that, a property owner could say, gosh, I want that extra speed and I'm willing to pay a lot of money for it because I'm doing it. But the neighbor might say, I don't want that extra speed. So they would say, I'm not going to participate, which may mean more cost to the other property owners that want to participate. Or someone might say, decided, gosh, I really, at the end of the day, I don't like the assessment. I want to look at that. So we start the process, by the petition method, but the commission always passes it. We probably require some kind of no protest to the formation from the parties that want to participate. We require an agreement to not protest the formation. So we get over the formation of the LUD. But every property owner in the LUD has the right to question the special benefit at the end of whether their property has the benefit of it. So it really puts the impetus on a good estimate at the beginning and a communication throughout the process of what the cost will be.
Well, Commissioner, that really highlights one of the potential flaws in this whole system. So Kitsap has gone and looked at it, and in their county, in their general region, putting fiber to an unserved property adds about $7,500, $8,000 to the value of the property. And that's just kind of what they've determined. If the property already has internet and it's going to a faster speed, they've determined that adds about $1,000 to the parcel, to the value of the parcel. The issue that we've got is if you're running out to a property and it improves the value of the property $10,000, but it costs you $100,000. Even if the person's willing to finance it in the LUD, I'm not really sure you can assess them a value higher than the value that you're adding to the property. So that ends up with another problem.
You can assess them if they don't object.
If they don't object.
Yeah.
Well, I just want to make sure that there is a place in there that the owner has the right to decide whether they want to participate in this or not, because to me, this is way different than roads and sewer and water. This is, to me, if you have your business, you need it, you're that high speed, I would think that you would jump at it. But for somebody like retired and just happy to get a few things and are okay with the slower, then I think they have the right to choose that and not be impacted by a tax increase.
If I may.
Yeah, and for sure, everybody can opt out. The whole point is that this model doesn't force anyone to participate, just to be clear.
Yeah, that's a policy decision the commission will make, because you can force a property in over an objection and try to force that through the preliminary assessment rule. That's a political policy issue for the commission to decide.
Oh, really?
You
Okay.
may make the decision that you were just relaying, that we're not going to include property owners that don't want to be in, and then we'll have to find a way to draw the boundaries.
Yeah. Okay.
And I'm good,
Thank you for that.
I understand that, but if there's, say, 8,000 homes in this area and 1,000 of them even says, no, I don't want it, does that 1,000 have a right to walk away from it? Or does we as a commissioner board say, no, we have 7,000 over here says they want it, we're going to force the other 1,000 to pay for it?
You can try to force them in. That's the policy political decision. If you don't want to force them in, then we will just have to find a way to draw the boundary to exclude them.
And it would spread the fixed costs over a somewhat smaller population. So those would be higher for the people who are in. So that's the downside. So today, we're not asking the commission to approve the LUD process or anything like that. What we're doing is giving you an update on where we are with our research. And what I expect will happen is that we'll come back to the commission at some point and say, we have this particular community and they want to do some self-financing or other financing, and staff recommends using an LUD model. Here's how that would look. Do you approve going forward? So I think we're going to bring it to you on a case-by-case basis. I can't predict whether we'll have any or if we'll have dozens with all kinds of different financing models.
Right, and it's not just saying we want to do it. You still need to have the financial institution that will do the lending. So it's not the PUD can't just operate on its own. You need to find a financial institution that'll do the lending or go to the bond market. The last thing I want to say is the commissioner had asked me to look at Mason for the LUDs that they thought were doing there, and they're not doing LUDs. The only LUD, so Mason has this process of fiberhood, and they've just decided to essentially self-finance through connection charges to areas, and they find high density areas that are priority possible connections that they predetermined. And when there is a critical mass from the pre-identified areas that request connection, it's like 75% of an area, and they have a preset connection charge, flat fee. When those folks, enough people come in and say, we're willing to do it, then they create their fiber neighborhood and they go out and run it because they have 75% of the area has said they will connect and pay the charge. Now they think they have enough commitment that they can leverage and pay for the cost of extension. So it's the Mason
It's a little
fiber,
different.
It's a lot different. It means you have enough critical mass who are willing to pay upfront, and they predetermined densified areas that are accessible. And Mason has a co-location facility, and it has some middle mile already developed. So it's really a different scenario. So Whatcom, my sense is from comparing to Kitsap to Mason, they've used, those two entities have used different models, but they're also in a much different geographic density situation than Whatcom is. So it was a little different for Whatcom PUD to pursue the financing methodologies and how to allocate costs. Not
John.
insurmountable, but different.
So, Mike, do you have any further questions?
I have none, O'Toole.
So I have many, but I won't discuss them today because this is just a relatively brief conversation, and I want to set the record today.
We want to let you know that the PUD was engaged in looking at this, and it wasn't something that the commission had tabled indefinitely. You've asked us to look at this. We've been looking at it actively last month or so and gave you a report last time in executive session. We gave you a public report today where we're at.
Yeah, and I think that so let me just summarize this way today's discussions to this point, and then the LED subject. For a couple of years, I and other commissioners have been curious about this model. That culminated with the presentation by the general manager of Kitsap PUD. Certainly was an excellent presentation, very informative, and certainly presented a positive spin on the potential, not just spin, but and their substantiated experience undertaking LEDs for many years. And this is a very beneficial conversation as well, introducing some of the challenges and concerns that that might result from if Whatcom PUD embraces an LUD model. Certainly, adding some new information to the subject of pursuing this model. So that's for the benefit of the public and my summary of what's happened so far at our commission meetings. I have a few questions for my own education that I'd like to raise that are, I would say, at this point for me, relatively minor issues, but they would help me in my education. The first question, John, is that the LED model is something that PUDs can pursue, but is it correct to say that there's all kinds of local governments that use and pursue LUDs? And I would like to know what kind of entities can pursue an LED model. Can they be entities that are quasi-governmental? Can an entity be a homeowners association that pursues an LED? Like, what's the threshold for being able to pursue the LED model for financing?
The LED model is used by municipal governments to finance municipal infrastructure. So a homeowners association would not do a LUD because LUDs or LIDs are creatures of statutes, and powers granted by the legislature to local governments. A homeowners association, if it was looking to do something like this, it would be a private agreement with a financial institution to say, subdivision ABC has 200 homes that want to have fiber run to it. They go to a local bank that says, listen, we'll charge through our homeowners association a supplemental assessment for fiber, and we'll pass that by the board. So we have an annual assessment. Local bank, given that we can do this and have authorized it, will you finance the cost of extending the fiber to us on this basis? The bank creates its deal with the homeowners association for the subdivision, and the homeowners association goes to an ISP to extend the fiber. That ISP presumably has a franchise with the county or city to run the fiber down the right of ways and through the private easements in the subdivision and runs it to the home. And that is something that the PUD would be completely outside of. It is something a homeowners association would undertake through their own board and through a local financial.
You said municipal, but don't fire districts utilize this model?
Well, they're a special purpose government. I don't believe fire districts do LUDs because they're not, they do special benefit charges.
Okay,
They have a taxing authority. But forming an LUD for construction of infrastructure is not how fire districts finance their stations.
yeah,
And
something
fire
that
districts-
maybe we don't have to resolve the minutia here, but I just want you to know, John and Chris and Mike, that that's something I'm curious about. What are the different vehicles for aggregating and pooling resources? And it's something that, I look forward to talking about in future commission meetings as we discuss financing models.
The LUD is certainly an opportunity for financing. I think the scenario in Whatcom County is a bit different than Kitsap and Mason. And the difference will be depending on, as Chris said, a case-by-case basis for who is trying to connect and whether the costs are, whether they accept the costs and how you can do that. And that there's a process to get there. And do you have the financial institution that will do the financing on the back of assessments for that particular area? And can you survive? Is there a risk of challenge? So it's an opportunity. It's a case-by-case analysis. You can collaborate with other entities. You could do, you could do daisy chain LUDs from neighborhood to neighborhood to neighborhood to try to connect one area to connect another area, to connect another area and extend it out that way. There could be some very strategic approaches, but it takes a bit of study and analysis to get to that point. I think Kitsap had a critical mass of some rather dense areas to serve.
Well, and
Let me,
both
John, I don't
Kitsap-
want to
hang
belabor this.
on a second, Atul. I
I'm
want to say
sorry.
something important here. I want to say something important here. The difference in Kitsap was they had a co-location center and a middle mile that they were building out to support their AMI. So they were going to build fiber anyway. And so for them, they already had proximity with their facilities. Mason established a co-location center and began running middle mile. That's how they determined where these neighborhoods, the fiberhoods, are. So regardless of what kind of financing model we ultimately look at here, I can almost with complete certainty say that if we use an LUD model, it will look different than what Kitsap is doing. And if we use a fiberhood model, it will look different than what Mason is doing. So, all of those are things that we ought to look at and learn from, but we're going to have to do what's right for Whatcom County, not necessarily ape what some other county does.
Okay. So my first question, coming back to what I was addressing, was that regarding LUDs and financing, I wanted to understand what the scope is. John, you answered some aspects of that. There's further work to be done to figure out what other adjacent financing models there might be, what the depth of an LUD financing model is. And it's something that we will discuss further. The other topic that and I'll come back to what you said, Chris, in a minute. And what John, you talked about the differences between Whatcom and Kitsap. But first, the other high level point I wanted to make for future discussion, not resolution today, is that all these cases are truly different. There's a tremendous array of projects happening in Washington State with various funding models. Mason, of course, Kitsap, of course, but in other communities as well. So it strikes me that the most important thing for us to focus on next might be, and I look forward to discussing this, I'm not proposing anything, but it occurs to me that the next step is not analysis of legal and risk issues, is to do a richer job of intake. So the fiberhood model at Mason is very dependent on a thorough process of analysis and intake, understanding the community that you're looking to explore. The LUD model in Kitsap is very dependent on a thorough job of intake. By the way, as an aside, not explicitly relevant to this topic, but discussions of whether retail happen or not in a particular community, public or not, is also very dependent on a thorough job of intake. Being an industrial PUD, we have a ways to go as far as developing that kind of rapport and intimacy with the community where we get those kinds of feedback and intake. We had a mixed success with our public event, open house on broadband. And certainly we benefited from it. But there's something for us to think about as a community at the PUD and our relationship with our community in Whatcom County, to think about how we do intake and how we understand the needs and wants of our community as it relates to fiber. And so many times I've seen in local government, certainly in government as a whole, that sometimes we forget the local in local government, and we forget about how important it is to interact with community as we're developing particularly new models of serving the community. So I'm not proposing a solution. I have ideas, but I need some time to sit on those. And maybe at our next meeting, I'll bring some of those ideas forward. But I think it's a topic that probably needs careful attention at the commission. And now to address the point of Whatcom County is not Kitsap County, is not Mason County. Absolutely, every community is different. And I would say Whatcom County is not Whatcom County, meaning that there's such a heterogeneity of projects that could happen in Whatcom County. So that again begs the question of intake in the particular community, analysis in a particular community. And then that's also something for us to recognize let's say a skill set or a competency within our organization that certainly our team is highly competent, capable, but a practice that we need to discover. So I'm glad we had this conversation. I think it requires further reflection. And I look forward to talking about it more.
So the last thing I have to report on broadband, commissioners, is we're making the progress you would expect on all of the grant applications and project administration, the NUCSAC project. should break ground here in September. And current schedule is we'll finish stringing fiber, first phase of the Nooksack project sometime early December. Just as a reminder, this is part of the state-funded and federal-funded fiber grant that we're jointly working with the port. And so, Atul, to your point, there's many different parts of this county, and you can expect us to attempt to deal with them in many different ways, and we are.
Thank you. Thank you.
That's
Thanks.
all I have with regards to broadband.
Hi, Brian. Are you on for the next agenda item, or did you want to add the last word on broadband?
No, I'm on for the next item, Commissioner.
I'm just teasing you. So Chris, is Brian going to handle item 5C?
He will.
Yeah.
Thank you, John. Please go ahead.
Commissioners, I'll start out the discussion, but then I'm going to ask John Sitkin to weigh in on this item as well. As you may recollect, in the June 14th commission meeting, commissioners approved professional services agreement and work order number 1 with Electric Reliability Services. And their scope of work under the first work order was to do testing and maintenance in our refinery substation. Well, subsequent to the approval of the documents, we forwarded them on to Electric Reliability Services for signature and return. Upon their corporate attorneys for the parent company, Vertev, their corporate attorneys' review of the professional service agreement, they got a little bit of cold feet and were concerned about their liability should something go wrong when they're doing testing work in the refinery substation, i.e. if we drop the refinery or, there was an equipment failure, etc. So rather than sign the agreements, what they did was forwarded for our review a draft addendum to the agreement that essentially absolved them. They would not indemnify us against any consequential damages associated with anything that they might have done that goes wrong, and a third party, i.e. the refinery, comes after us. Well, their drafting of that document was not acceptable to us. We couldn't absolve them of that liability, nor did we want to take that liability on ourselves. So at that point, with John's help, we had a conference call with their corporate attorney and one of the staff for Electric Reliability Services. A little back and forth there, but the end result was that they basically listened to what John had to say. John, as you should have the document before you, but John prepared some language that they determined was acceptable. And as a result, our liability issues were addressed as were theirs. So I guess with that, I'll turn it over to John for further comment.
So in short, their changes were that they wanted to eliminate consequential damages and incidental damages from their indemnification, which would mean business interruption, lost profits, loss of use, etc. And for a refinery that was shut down for a day or two, that could be quite consequential and substantial. And it could be a result of the work that Energy Reliability had done, or their performance or negligence. So not that they would be negligence, but this is the risk we're managing to. And so we went back and said, that's not acceptable. You have to cover incidental and consequential damages. And we're not going to cap it at $5 million, which was another cap they had put into their agreement on liability. And they accepted that. I frankly think they accepted that because if they had such a claim that we moved to them, they'd just shut down and reform as a new company and tender all their insurance and say, do whatever you want. But judgments are only as good as there are money to pay them. And so this would be, I'm sure, why they conceded to the changes we required, but this is what they conceded to our demands or requirements that they cover, their indemnification cover consequential damages without a cap.
And
This
it's
would
not
be an
a,
issue, this would be an issue with any kind of consulting firm, where their extent of their exposure is usually the extent of their liability insurance.
And if I'll want to add too, that we believe this company to be a solid company. We've worked with them before. They do excellent work. And at a staff level, we don't see that there's a huge risk here. It's just that we can't take that on. So we've done this type of work numerous times in the past. We have to do it on a regular schedule. So here we
And
are.
the fundamental purpose of the work is to extend the life of the assets and improve the reliability of the substations. So, you know, the work itself actually works against the risk, if you will.
Yeah.
So this is a normal function that everybody who owns a substation has to go through, and this is to us a very reasonable document that we're asking you guys to approve.
The last edit in there, I will just tell you, is that our agreement did not have a deadline by calendar days for payment of an invoice. It would be processed in the normal course. They wanted 30 days. We said, listen, we can't assure that, because what if a commission meeting is canceled and we received it the day after a commission meeting, we don't have a commission meeting for 35 days, we're not going to put ourselves in breach. So we always ask for, we have to have a calendar day, we say 45 days. Because that should get us through processing with commission meetings and the county. Unless there's questions.
so this subject of indemnification is something that is not, we're not alien to. Consequential and incidental damage is something we've experienced intimately. So that's just a comment, but let's go to Commissioner Murphy first for questions.
After looking over what has been done here and the corrections that John made, I have no questions.
Okay, so the returning back to the comment I made, incidental damages is not something we're unexperienced with. And the need to be indemnified against incidental damage is not something we're unexperienced with. So in that regard, can we think about some of the scenarios that have happened to us and some of the scenarios that might happen to us as a result of the work that's going to be conducted with this particular vendor? And whether,
Well, I think, without getting to the specifics works, maybe Brian or Chris can do that. I would just say the economics of this, given our limited customer base, if there was a major liability that cost $10 million and they made a claim against us for $10 million, we turn around and say, okay, it's in your rates. This would be within the utility, there would be a cost to that utility, and it would be paid out through rates charged back to this utility. That's why Conoco, I think, when we had the incidents last time, and Brian can speak to, they were frustrated, complained, but what are they going to do? Because it's not like they can go against a large rate base and try to minimize their costs against the utility. We're going to turn around and just charge them the cost back in the rate.
It's a cost of doing business.
It's the cost of doing business, and they're the customer. I mean, we just don't have a big customer base to spread the risk to.
So our recommendation, staff and legal recommendation at this point, is that that you guys approve this as it's written, and we move on and just do the work.
Yeah.
so the question regarding to you, Chris, and particularly Brian, because of the historical experience, what have you done regarding the looking at some of the potential scenarios and risks that might occur, and then how, if they're being appropriately addressed with this agreement within the context of liability? I'm not talking about major disruptions, but perhaps disruptions that would be covered under expanded indemnification.
Yeah, I guess I can address that, Commissioner. We've taken several steps over the past few years, but number one, any work in the substation, we don't allow a subcontractor in that substation without our staff present. And so we're on site when they're doing their work, number one. The other thing, prior to any work, we have team meetings. Those meetings involve not only the contractor and ourselves, but we have meetings with the refinery staff. So we're working in close coordination with what they're doing on their side of the fence versus what we're doing inside of the fence. And so it's sort of an all hands on deck, go through the scenarios. Okay, we're going to do this. What could go wrong? Well, if that happens, we'll do this. It's, sort of a step-by-step analysis. This is the next work we're going to do. What impact might that have? This type of thing. So there is a thorough review prior to the start of any kind of work in that substation. And in particularly, for the most part, we got to work in a substation that remains energized to serve the refinery's needs. So that even makes it more important that we're working very close coordination, contractors, our staff, refinery staff.
So I think what you're bringing up is that the process that we have in place to not require indemnification, meaning where it wouldn't be an insurance triggering event. And that's helpful to know. And getting back to the question, what about processes that what about the likelihood of actually requiring them to pay under the indemnification clause for things that aren't foreseen?
Well, Commissioner, I think in that case, you have a claim from a third party that triggers whether or not the insurance is engaged or if it's above that limit. And at that point, you would deal with it as it occurs. We could sit here and speculate all day long about 10,000 different potential failures that we're in fact doing all this work to avoid in the first place.
Right.
We could have a huge failure tree analysis and go through all that. That frankly is hunting mosquitoes with a howitzer. And
and I don't want to make light of my question. So let's start. The reason I'm bringing this up is that there's things that we do to avoid triggering indemnification clauses. There's major failures that go beyond what any vendor can reasonably expect to have to deal with. And then there's what falls within a claim. And I would just, my original question was about what are the kind of situations that we've looked at that would fall under a claim and a requirement for indemnification. That's my question.
So the fundamental issue is when you have work that you're doing in a substation and you have a misoperation of a breaker, which causes an unanticipated interruption of customer service. You've got to take a look at what happens downstream, and it'll be up to the customer to determine what damage, if any, occurred as a result of that unintentional interruption. That's the event you're always guarding against. And Brian talked about all the work that you do up front. It's to avoid those unintended interruptions of service that you have, all kinds of grounding schemes, training, you've got orientation when you come on board, you've got the work process itself. All of that is to avoid uninterrupted outages. That is the purpose of the work.
Yeah, for sure. Thank you for that example, Chris. This example of an outage that was unforeseen. Is that from your perspective, Chris and Brian, a good example of what potentially could be the kind of thing we'd request indemnification on?
I would think so. The other would be, in terms of process, was when we had the the subcontractor to our main contractor that bored into our water line. We went through a process and ended up in civil court. So, or almost ended up in civil court.
And would you say
So
that,
we have processes in place to handle that, and where we need that indemnification.
yeah, yeah. Yeah, I mean, obviously, the claim is the preferred way rather than the court, obviously. Yeah, but if the insurance provider also is not cooperative, then we can end up in court. So no, I'm just curious and just, continually improving my understanding on the subject of how we deal with unintended outcomes. So thanks for the discussion, Chris and Brian. I have no further questions, and I think, Mike, do you have any more questions based on what we talked about here?
I do not, but I'll make a motion that we approve this agreement
As revised.
Sure.
as revised.
Please. So the motion is then to approve the addendum to the professional services agreement with Electric Reliability Services. Do we have any additional names, numbers, or what we want to put on that? Or is that just fine, John?
That's just fine.
Okay, great. So that's
Approval of the
the mo-
addendum
and I'll
as
second-
revised.
and I'll second that motion. And so we have a motion and a second. All those in favor, please signify by saying aye.
Aye.
Aye. So that completes the old business. Let's move on to the general manager's report.
Thank you, Commissioner. I've got 4 quick things to talk about. The first is starting with our next commission meeting. I am going to call on one of my department heads to give you guys an operational update. This first up will be Brian. At some point, we'll also hear from Rebecca. We'll hear from, of course, we hear from Andrew every meeting, except when he's not here, such as today. But the idea is that I want to get all of the operational stuff kind of at a higher level so that people can see it and they hear about it periodically. We do everything we talk about here seems to be around broadband, and in fact, we run a utility that serves customers, and we've got a ton of work going on, and I just want to make sure that you guys can still see that and appreciate the good work that all of our folks are doing. So that's the first thing. The second thing is we did an RFP for an electric feasibility study, and the close date was last Friday. We got 2 submissions, and we're in the process of evaluating those now. And I hope to bring the results of that evaluation to the commission either the next meeting or the meeting after with a recommendation. The third thing is Commissioner Grant asked me to report on her behalf. So she attended the telecom meeting and the general government meeting and the broadband meeting for WPUDA. And Commissioner Dashmani, I think you were in all of those. I'm not sure if you were in the general government one.
No, I don't think I attended government relations.
Okay, and Commissioner Grant had copious notes on it. And
Well, actually, I did. I'm sorry. I did attend government relations.
yeah, I thought you were there.
Yeah, I don't think I left. I think I was there all day.
Yeah, I recall.
It was
every time
100
I was
degrees
there, you were
outside
on.
and it was cooler inside.
So anyway, Commissioner Grant, she had a lot of observations on the electric and the telecom. It was all pretty good. And just to note that we did have a significant presentation from the broadband director, and it was an interesting presentation, and I'll leave the characterization at that. The last thing I want to talk about is the Humphreys public records request is now at over $28,000. So that is the, just as a, so you recall, we got a public records request for all emails for a particular period of time. And we have to go through that and produce all of those emails, redact personal identifying information out of them. And then we also have to have John's organization redact all the attorney-client privilege and then any other information that we should have redacted before then that we didn't catch.
And we have to prepare an exemption log
and an exemption log. And yeah, there's a ton of work that needs to be done. So to date, the bill for that is a little bit over $28,000 and still climbing. So at some point when we issue the final batch of documents to Mr. Humphreys, I'll be able to give you a final count on what the costs are for that particular public records request. So with that, I have nothing else to report.
Let's move on to, thank you, Chris.
Well,
Let's move on to commissioner reports. Mike, do you have anything?
I don't, I did attend the WAPUDA roundtable and government committee. Chris got to be there at the government. That's the first time you've been to the government?
Yep.
Yeah, okay.
yeah, my schedules just really clashed before, but it was, it's not the world I've operated in. So it was kind of interesting to listen to.
And also the board. And I really don't have anything to report on those things.
Okay, so I will just provide a brief comment on telecom first. There was quite a bit of concern over the comments by the director of the broadband office from the state as it relates to open access. And it appeared that he was trying to take some new direction in terms of not supporting open access in as far as public sector infrastructure and fiber. And luckily it's codified in law. So I personally am very passionate about open access as a foundation stone on public broadband. But it certainly will have an opportunity to provide input. And I made a proposal to do a listening session next time we meet in Olympia, which will probably be in the early to late summer or early fall. And we'll have an opportunity to reemphasize that point then. And then, of course, in the interim, some of the involved PUDs are already engaging on the subject. And the opportunity for a listening session Olympia will probably be helpful on multiple fronts. This particular broadband director has not spent a ton of time out meeting with PUDs, and it'll be an opportunity for us to come to him and talk about some of our realities. It's possible that these gaps between potential gaps might be resolvable through further dialogue and discussion. On the subject of energy, I think the Energy Committee got to a place which was beneficially impacted and informed by contributions from Christine Grant, Chris, and myself in terms of the energy policy positions as they relate to how we engage with the state's desire to increasingly address challenges with the climate and taking actions that mitigate our impact on the climate, while at the same time maintaining the truly important role of grid reliability. Without opening the whole subject up, I think it's fair to say that it was a good example of our PUD contributing to state level policy. And then on this subject of water, there's a water committee meeting that we're at water workshop that's happening September 21st, 2nd, 3rd, I believe, in Spokane. I'm looking forward to attend that. Lots of people curious about what's going on in Whatcom County. There's not a lot to report because everybody's kind of hunkering down and preparing for adjudication. As far as anything new, of course, the work of the Watershed Management Board, which next meeting is now in August, will continue taking all the actions under the 5-year plan that that continually gets updated to improve the situation for the watershed, and also very focused on salmon. On that subject of water, Steve, is there anything you'd like to add about Wapuda water-related meetings that I might have missed?
Just that I think there was some good discussion at the roundtable, and good input and questions that you responded to, and I had an opportunity to add a couple of comments, but you might want to talk more about that, because I think
Right.
that, yeah, that's all I'd have.
You're right. I believe the topic that Anna and you were very helpful. I want to thank you for that, Steve. At the water committee meeting, and the topics that were asked about were what's happening in our community as it relates to action under the Hearst legislation and the funding that came out of that. And the response I gave is that we've tried a lot of things. And some of those have been partially successful. And some of those things are still to reach some kind of a fruition. So the honest fact is that we're looking for wins and we don't have them yet. But our PUD certainly has a long track record of proposing ideas. For example, California Creek, which it's a fun buzzword to bring up for our community. We look forward to keep at it and to be able to come back to Wapuda and the state with some real solid wins for the community as it relates to habitat creation, in-stream flows, and so on and so forth. We're doubling our efforts, perhaps I could say, is that and trying to bring to some communities some wins as it relates to those subjects, but don't have a lot to report of in that area. I also wanted to say that Bill Clark wasn't present in the meeting, and Steve, and maybe we can follow up. I don't know when Bill is back, but I'm wondering if that maybe it was my perception that the departure of the long-serving water committee staff, a position whose name is, can you help me, Steve?
John Counts.
John Counts. I can't believe I forgot his name. I'm feeling a little bit, particularly when Bill Clark isn't there. And it's something that I plan to, and I'm glad we had this little the opportunity to bring this up, because it's something that after the meeting I wondered about how to constructively mention that some of the horsepower in the water area is missed that Wapuda had.
Yeah, John had a long-standing relationship, not only with, at Wapuda, but with so many of the water, or so many of the PUDs, but also related back to the legislature, even though Bill Clark is our quote water lobbyist at the legislature, John had so many years experience and so many relationships that I'm not so sure why the PUD Association hasn't replaced him, but.
Yeah, and then maybe it's something for us to have a conversation about at the water, at the right time.
Yeah.
I don't have anything more to report about Wapuda meetings, which is the primary thing that I participated. I also want to alert folks that the city is dramatically increased the frequency of its meetings. The voting members of the city's broadband advisory group are asking lots of questions of the ex officio members like myself to come up with policy positions that they want to recommend to the city. But one piece that seems to be fairly stable that I'd like to report on is that the Broadband Advisory Group is going to recommend, likely, it's not official, to the city that they invest more heavily in the city's dedicated fiber infrastructure that they use to serve their, things like the libraries, water treatment plants, et cetera, essential services, their essential services fiber network. The committee seems to be encouraging the city to invest more, to support that more, and then start providing some degree of public access, open access, or other services off of that fiber that the city owns. And the other aspect is that the city did explore an exclusive retail full fiber network to the entire city as a particular example of that of a scenario to look at. And it appears that the committee is saying, based on the numbers, that that's probably not the best idea. Now, that was probably a foregone conclusion before any work began, because the city is relatively well served, and to create a redundant exclusive fiber network to all the residents of the city, probably nobody would have ever suggested that was a good idea. But anyway, it's good that Magellan thinks so too. Much more to report on that. And that will be in the form of a memo from the advisory group. That's it for me.
Commissioner, I think that takes us to our last public comment session.
Yeah.
Commissioners, at this time, I do not see anyone with their hand raised.
Thanks, Rebecca.
Mr. Miracle, do you have anything? And nobody here in the commission meeting room.
Okay, well, with no further public comment, it's 9:22. I'm afraid I didn't achieve my goal, but it's okay. We did good work and had good conversation. It's 9:22. If there's no further action for the good of the order, let's proceed and adjourn. Thank you. Bye-bye, Mike. Bye-bye.
Bye-bye.